can't say yes or no on that until they get done with their presentation. I think it may be brief, if at all, but again, I don't know that at all. It's not gonna, it would not affect the scheduling, I think we generally understand to be.
You have 3 witnesses?
Well, 2 for today.
I was going to just advise you, over the lunch break, we kind of reevaluated who we had left to call. 2 of our witnesses, we believe there was substantial overlap, and sometimes you kind of get a sense that, you put more witnesses on than you really need, that, it could adversely affect your case. So we have decided to eliminate the number of witnesses that we had called. We had brought, he was here this morning. We decided to only go with one of the doctors that we had brought, just as a matter of strategy, Your Honor.
Okay. So who do you anticipate this afternoon?
Dr. Danzinger, as well as Judge Tinlin.
Okay.
And that'll be it for today. And then tomorrow morning, our plan is to call Dr. Meadows.
Okay.
Yeah, and Ms. Dunn just brought up that we might need to take a break between Dr. Danzinger and Judge Tinlin, because I think he has court going on, and so he said that he could take a break from his proceedings to come and testify. So to do that.
All right. Proceed accordingly.
There is one, if I may, Judge. We had talked earlier this morning about the issue with the incidents of prior violence. And there was some discussion about potentially the door being open to certain of those. Based on the testimony that we've heard, I think some of it was yesterday, and there was some more today, that we do believe the door has been opened. And that's regard, there was some testimony about the defendant's treatment of animals. One of the specific instances that was reviewed by the doctors was the complaint by the victim in this case in her injunction petition, which outlined the defendant threatening to kill her dog. And we would like to ask the doctor about that, but obviously before I even did that, I wanted to make you aware of that, what our desire is to do, and to be your honor to make a ruling on whether or not you believe the door has been open to that. So.
Okay, Mr. Wood, briefly.
Judge, what Mr. Johnson is referring to is a statement that's contained in the injunction petition that Amanda Colley had filed previous to the case, and the court's certainly aware of the existence of that. That's the only source of the information. It's clearly hearsay. There's no corroboration to that hearsay statement. I believe it's just one line in her petition. There's nothing to verify the allegation, and it would be, as I understand Dr. Danziger's testimony, will be regarding the rebuttal of the impairment aspect of the defense for the penalty phase. So I believe would be not only irrelevant, unduly prejudicial, and it's hearsay.
We're in the penalty phase, so that the hearsay rules get relaxed.
I'm sorry, I don't mean to cut you off. But yes, under the case law, if hearsay is permitted, as long as the defendant's constitutional rights for confrontation are not violated. There's no way we can cross-examine, unfortunately, Ms. Colley because of that statement. So it's really a backdoor hearsay approach. It's not, I'm not saying that in a heinous way or anything like that, but it is what it is. It'd be like any other type of statement written by somebody else. It is hearsay, and there's no way we can confront that. It's a violation of his U.S. constitutional confrontation rights as well as Florida constitutional rights.
This was just allegedly a comment of a threat to harm the animal as opposed to an actual act against an animal.
That's my understanding, Judge.
Okay, I'm not going to allow the testimony.
Okay, thank you, Judge.
Okay. Everybody else, everybody ready? All right, let's go ahead and bring the jury in. Welcome back. Welcome to the courtroom. Everybody, thank you very much. And we are ready to proceed. Now, Mr. Wood, do you have any further witnesses?
No, Judge, we rest.
All right, ladies and gentlemen, you've heard the defense just rested its case. The state has an opportunity to present rebuttal evidence if it so desires. So does the state move forward with rebuttal evidence?
We do, Your Honor. In the state, we call Dr. Jeffrey Danziger.
Dr. Danziger, you'll go to stand right here and remain standing when you get there.
Do you solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
I do. Good afternoon, Your Honor. Good afternoon. You can be seated. Mr. Johnson, you may proceed when you're ready.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon, Mr.
Could you introduce yourself to the jury?
My name is Jeffrey Danziger, and I'm a psychiatrist in Maitland, Florida, just outside of Orlando.
And doctor, just for the benefit of our court, you spell your last name.
It's Danziger.
And you believe you indicated that you are practice as a psychiatrist, is that correct?
Yes.
And can you kind of outline the nature of your work that you do as a psychiatrist?
Over the past years, I've done several things as a psychiatrist, which is a medical doctor. I treat patients. I saw patients in the office yesterday. I'll see people in the office tomorrow. And it's a general psychiatric practice. People who suffer from depression, anxiety, bipolar disorder, schizophrenia, panic disorder. I'm a treating doctor to them. Also, over the years, I've been involved in many drug studies where I'm the principal investigator, and oftentimes these are medications not yet on the market to treat depression, schizophrenia, or bipolar, or they're medicines already out on the market but for a new purpose. And the third hat that I wear is what I'm doing today as a forensic psychiatrist. So I'm not in a treatment role today, but I'm taking medical and scientific information and offering opinions about somebody's mental state here in court to juries, judges, and lawyers. So essentially, I wear three hats as a psychiatrist, and today I'm here as a forensic, not a treating doctor.
And you indicated that you're a medical doctor, correct?
Yes.
And you're, what, are you licensed in a particular state or states?
Yes, I'm only licensed in the state of Florida, my native state.
Okay. And how long have you been working as a psychiatrist?
Well, I started my internship and residency in 1982 after graduating medical school, so by that standard, it's been 38 years. If you do it for when I finished my training in 1986, it would be 32 years, so a long time.
And you kind of got into it just a little bit there, but can you maybe a little bit in more detail, not particularly in depth, but describe your education as it pertains to this field?
Sure. I graduated from North Miami Beach Senior High School in Dade County, and then I went to Harvard College, Cambridge, Massachusetts, graduating in 1978 with a bachelor's degree in biology. I then went back to my home state of Florida and went to the University of Miami School of Medicine, and I got my MD in 1982. I then went to St. Louis, Missouri, to the Washington University School of Medicine, and I did my internship and residency in psychiatry. You can think of internship and residency as an apprentice for young doctors. You come out of medical school, you have an MD, but you need several years additional training, usually in a university setting. So after finishing my residency, I spent 1 year on the faculty at Washington University, and then once again came back to my home state of Florida. And I've been in Central Florida since 1987, practicing in the Orlando area. And in addition, I have a number of board certifications. So I am board certified in psychiatry, addiction psychiatry, geriatric psychiatry, and forensic psychiatry.
And Dr. Danziger, have you ever testified in court before?
Yes, I have.
And how many times have you done that?
Over the past 30 years, many times, 600, 700, a very large number, over 30 years.
Okay. And have you testified in death penalty cases?
Yes.
And with regard to your testimony in death penalty cases, Have you testified for both the state and the defense?
Over the years, it's been about 50-50. So some of them have been at the trial level, such as today. Sometimes they come back on appeal, and there's more courtroom testimony. So I've been involved at both the trial level and on the appeals, which may take place years later. And it's been about 50-50 over the years, either on the defense side or on the prosecution side.
Death penalty cases?
Yes, on death penalty cases.
And what about just in criminal cases in general?
Well, in criminal cases, I'm often appointed by a judge, and I may be asked to do competency, which is what's their mental state today? Are they mentally able to understand what's going on with the case and work with their lawyer? Or I may be asked to testify as to their sanity or mental state at the time, or sometimes even mitigation reasons that the court might choose to treat someone with some leniency or give them a lesser sentence. So in many cases, it's the judge who appoints me, so my opinion falls where it may. I'm also often retained by defense attorneys, sometimes the public defender's office, sometimes private attorneys, and less often, but occasionally, by the state attorney's office, such as I'm doing today. So probably 50% court appointed, 45% a defense attorney retains me, and probably around 5% it's the state that actually retains me.
Okay. So out of the times you testified, only 5% of the time you're testifying on behalf of the state.
Well, not quite, because, and it's complicated, but when I do a court-ordered opinion, sometimes my opinion favors the state, and then the state asks me to come testify. So I was originally retained by the state. The judge asked me to see someone. My opinion favored the state, and then the state calls me as a witness. So my actual testimony is more 50-50.
And I want to talk to you about this particular case. Were you asked, Dr. Danzinger, to review materials regarding the defendant's state of mind at the time that the crimes were committed, in this case on August the 27th of 2015?
Yes, I was.
And do you recall approximately when you were asked to do that?
Sure. I first spoke with Ms. Dunton around June 14, just last month, and after figuring out whether I had enough time to do this case on June 19, you all formally retained me to get involved in this case, so just 5 weeks ago, basically.
And just to kind of talk about some of the materials that you received, you received a number of, and I will just kind of go through some of them, kind of highlight some of them. You received some transcripts of interviews and depositions of various individuals involved in the case?
Yes, I did.
Did you receive medical records of the defendant?
Yes, there were medical records from different sources, but yes.
And pharmacy records of the defendants?
Yes.
Did you receive a recording, audio or a video recording of a proceeding, a court proceeding that the defendant attended on August the 27th, 2015?
Yes, the audio recording, not the video.
You received a lot of other materials that you reviewed in consideration of any opinion that you might develop in this particular case, correct?
Yes.
And some of those may come up later on as we kind of go through your testimony. Did your work on the case also involve conducting an in-person, face-to-face evaluation of the defendant?
It did.
Okay, and where did that face-to-face evaluation occur?
It took place essentially across the street at the St. Johns County Jail here on Lewis Speedway Road.
And when did that occur?
On June 24, 2018, about a month ago at 10 o'clock in the morning.
And approximately how long did you spend with the defendant?
It began at 10 o'clock and ended at 1:20, so there were a few bathroom breaks and the like, but 3¼ hours, more or less.
Okay. Did you also, during the course of today's proceeding, were you also able to listen to the testimony from Dr. Daniel Buffington?
I was.
After reviewing all these materials that you received, after conducting your extensive evaluation of the defendant, after hearing and listening to Dr. Buffington's testimony, I'll just sort of start with what your opinion is, and then we'll kind of work back from there. Were you able to develop an opinion about the defendant's state of mind, specifically as it relates to the issue of impairment on the approximately 10:30 a.m. on the morning of August the 27th of 2015?
I do have such an opinion.
And what is that opinion, sir?
It is my opinion that Mr. Colley was not impaired by substances at approximately 10:30 in the morning on August 25, and he was not suffering from any parasomnia or disorder of sleep.
Okay. Yeah, I think you said August the 25th. Did you mean August the 27th?
I'm sorry, August 27, 2015.
Thank you, sir. And can we just walk through, Dr. Danziger, the basis for your opinion? What was it that you reviewed in the records that you received, information that you obtained from the defendant himself that led you to that opinion?
There were several factors that were important for me. The first was his behavior in the days and weeks before the events of August 27. And we know that he was working. He was working as a mortgage auditor. He was going to work every day, taking care of the children. We even saw photographs this morning of just a day or two before where he's coaching t-ball, where he's at a birthday party for his son. So even though he was on some antidepressant medications, there's nothing to indicate that his behavior was altered, peculiar, or acting oddly. In the days before, he apparently was acting normally, taking care of kids, going to work, going to birthday parties and recreational events.
And let me stop you there, Dr. Danziger. What is your understanding of when he was last prescribed some of the medications such as the Ambien, the Wellbutrin, the Cymbalta, that is really kind of the focus of everyone's attention here?
That would have been on August 10 when he saw his primary care physician, Dr. Sanchez, so 17 days before the murders of the two women.
Okay. And your testimony is that that from the time that he was prescribed those substances to the day of the homicide, there was no indication that he had any issues with these medications, correct?
Correct. And while theoretically these medications, which I frequently and often prescribe in my practice to my own patients, while there are side effects you can read about in a textbook that occur, most of these are rare and uncommon. So as I look at, were there any peculiarities in his behavior, impairing him from going to work, taking care of kids, coaching, enjoying a birthday party? Nothing in that 17-day time frame. That these antidepressant medications or coming off medications had any peculiar or bizarre effects on his mental state. It just wasn't there.
Let me talk a little bit about Dr. Buffington's testimony concerning the common side effects or some of the side effects that could occur taking any of these medications. Can you talk to us a little bit about how often or frequent it is that you would actually have all of the side effects that he was talking about versus some of the side effects, and how that sort of works and the research and things of that nature?
Well, one of these things that, as a doctor, I look at in prescribing someone Wellbutrin or Cymbalta, the medications that were given to Mr. Colley, or any of these psychiatric medications. Some of the side effects are fairly common. They may occur 5 or 10% of the time. Others are extremely rare and uncommon, less than 1%, maybe less than 1 in 1,000, or maybe only 1 or 2 reports in the whole country. So, for example, if someone's on Cymbalta, well, what may occur more than 5% of the time? Well, someone might have a little nausea or a dry mouth or a little constipation. Usually those side effects dissipate over time. But if they're very problematic, I might need to switch them. But much less common are things like inability to urinate or extreme confusion or abnormal bleeding problems. Those are very rare, but they don't. Some are pretty common, and I tell patients you might have this, that it's something that occurs 10 or 15% of the time. Others are extremely rare. Nobody's going to get all the side effects that are listed, and the more severe ones are generally rare and uncommon.
Can you talk to us a little bit about we talked about sort of Ambien? That was one of the medications at issue here. And we've heard a lot of testimony about the parasomnic effect that sometimes Ambien may have on folks. Can you talk to us a little bit about that, what that looks like, sort of the behaviors that you would see typically when someone's in that type of that state? Can you talk to us a little bit about that?
Sure. And a parasomnia simply means some abnormal event or experience during sleep. So it might be, for a good example, would be sleepwalking. That's a parasomnia, something that happens during sleep that's unexpected and shouldn't happen. Now, there are certainly reports that Ambien can cause people to engage in behaviors like eating or sex or driving a car, but generally these behaviors are poorly coordinated and people appear confused to someone else. So by way of example, I've had some Ambien DUI cases. Someone's in their underwear driving 4 miles an hour weaving down the street. They're stopped by the police and they're obviously impaired, but when they blow for alcohol, it's triple zeros. But they're obviously impaired and they wake up in jail later with no memory of how they got there. But they were obviously impaired to a layperson or to a police officer. So the idea that someone could later appear in court and testify relevantly and coherently would not be consistent with an Ambien confusional parasomnia state. It's absolutely inconsistent. So while Ambien can cause these things, you would expect to see someone acting sort of dazed, befuddled, out of sorts. Maybe they're eating, maybe they're driving a car badly, but if you talk to them, they're not right. And that's the distinction here. So while it can cause that effect, it's usually associated with people taking more than the 10 milligram dose. So it's usually associated with higher doses. You tend to see it when they first take Ambien, not down the road, but if they're going to have it, it tends to happen within the first day or first days when they take it. And it's generally associated with higher doses. And again, if they're in one of these Ambien-induced states where they're awake and engaging in what seems like some complex behavior, they are still out of sorts and dazed and confused.
And you said that usually these are the higher doses. In this particular case, what information did you have that you reviewed concerning how much the defendant said he took the morning of August the 27th of 2015?
When I directly spoke with Mr. Colley on June 24, he told me that he had 10 milligram tablets and he took 2 halves. So that would be 2 times 5 milligrams or 10 milligrams. And the dose is either 5 or 10 milligrams. That's the standard dose as recommended. So he did not tell me that he took more than he was prescribed. His doctor told him to take either half or whole. He took a whole.
And your testimony, as I understand it, is it correct that to see this type of behavior is if you're taking more than that recommended dosage?
Well, typically it's more common at higher doses. And to be fair, it can happen at 10 milligrams, but you're more likely to see it at extreme effects at higher doses. But still, you would expect if you talked to someone or saw someone at that time, they might be dressed oddly, acting oddly, seemingly dazed, not fully coherent or fully with it. They would not be able to engage in very complex discussions, such as behaving themselves and acting appropriately in a courtroom.
What about making decisions? First let's talk about, you mentioned a court. You were able to review an audio recording of a proceeding that the defendant attended on the morning of August the 27th of 2015, correct?
Correct.
And can you tell us, what you heard in that courtroom proceeding and how it relates to your opinion in this particular case that the defendant was not impaired at the time that this crime was committed?
Several things were relevant. First off, this was, of course, time-wise between when he reported taking the Ambien and the 10:30 murders. So it was closer in time to the taking of the Ambien. If there was going to be an Ambien effect, you would expect to see it at 9:30 if it was going to be there at 10:30. So it was closer in time to when he supposedly took the medicine. As I listened, he was sworn in. He answered questions appropriately: name, occupation, education, that he was not psychiatrically ill and not intoxicated. And as I listened to that, he responded to questions coherently, logically, appropriately. The judge went through the plea colloquy, which is, this is what we're doing today. Do you understand? Basically, do you understand what's going on? Are you happy with your lawyer? And so forth. He answered all those questions appropriately, and the plea was accepted. After the plea, Mr. Colley said some interesting things that suggest he was mentally intact. He was told he had to attend Bowers' intervention, and he accurately recalled that he'd already signed up, and I believe he had 24 more sessions to go. So he knew that he had signed up and exactly how many sessions were left. He then asked about how his probation could be terminated early. Came up with that on his own. In other words, he was sentenced to a year's probation. What do I have to do to get off it early, which is a reasonable thing to ask. And then, when he was told he had $474 in court costs, he spontaneously came up with the idea, I've already got a $500 bond, can I just apply that to the court costs? And the judge said, that's a good idea, and here's how you can get your change back. So these were all things he came up with on his own that reflect a solid understanding of his position. So he's not just answering questions, this is who I am, this is what I do. He's coming up with these spontaneous things. How can I get off probation early? Hey, can I take my bond money and apply that to the court costs? That suggests he's clear-headed. He's thinking logically. He's coming up with spontaneous things. And these are not overlearned things. Look, all of us have been driving cars since we're 16. We know how to put the keys in and start the ignition. So even in a dazed state, somebody could do that. Maybe they don't drive well, but they could do it. But to come up spontaneously with these ideas, moving the money, how do I get off probation, knowing exactly how many sessions I have left, when you listen to that, this is suggestive of someone who's clear-headed, thinking logically, coherent, appropriate. This is not someone who is dazed and impaired in any sort of sleepwalking state. Everything on that court appearance, to my opinion, as a psychiatrist, is consistent with someone who's logical and clear-headed and not someone who is impaired.
Did you also, Dr. Danzinger, review deposition transcripts from the judge in that particular case, Judge Charles Tinlin, as well as the defense attorney that represented the defendant that day, Kyle Bedford?
I did.
And did they provide information that you considered and relied upon with regard to their observations of the defendant that particular morning?
I did.
And what information did you have?
The judge in his deposition said he absolutely did not have any concerns about impairment. There were no overt signs, and that he would not have gone through the plea given any concerns that the defendant was not right. Similarly, the defense attorney in his deposition said that Mr. Colley was somewhat nervous, but he did not believe he was impaired, that Mr. Colley understood what I was saying to him, that he responded appropriately, that he understood the plea agreement, and the attorney said, if he didn't, I wouldn't have entered the plea. So both the judge and the lawyer, neither of them had any concerns that Mr. Colley was confused or out of it. Other than some nervousness, nobody had concerns that he was impaired at that moment, which was less than 90 minutes before the murders.
Did you also, Dr. Danzinger, review some evaluations that were conducted by other psychologists or psychiatrists in this particular case that had been hired by the defense?
Yes.
And was one of those individuals a Dr. Harry Kropp?
Yes.
And Dr. Kropp is a psychologist, is that correct?
Yes, he is.
And what specifically did you review as it relates to Dr. Kropp?
Dr. Kropp met with Mr. Colley in November 2015, which was less than 90 days after the shootings. So very close in time, not 3 years late, almost 3 years later like we are now. And what was very relevant to me in Dr. Kropp's report is the sentence where he said Mr. Colley described the events after court, saying he was hungover and just snapped. And what's relevant is there's no mention to memory loss, snapshots, blank periods. It simply said he described the events after court. Now that's different than what was told to Dr. Buffington and what was told to me, but that's very close in time. And one of the points that Dr. Buffington made as I sat in the back of the court was that that lack of memory was a factor for him in saying that Mr. Colley was impaired. But we had an interview taken less than 90 days afterwards where Mr. Colley apparently made no mention of lacking memory, can't remember, blanked out, a snapshot. Dr. Kropp wrote, he described the events after court. Dr. Kropp went on to state that Mr. Colley appreciated the nature, quality, and wrongfulness. So the story has changed over time. And if Dr. Kropp's got a full story of what happened, all the events after court, that would indicate intact memory and argue against impairment or confusion due to drugs.
What was your understanding of the purpose of Dr. Kropp's evaluation of the defendant at that time?
To do a forensic evaluation. Was he competent to stand trial? Was he sane at the time? Are there mitigating factors? Just a general assessment shortly in time after the offense.
And when you talk about competency, conducting a competency evaluation, are there specific criteria that a psychologist, a mental health expert, looks at that would be relevant to determining whether or not someone's impaired at the particular point in time that they commit a crime?
Well, yes, and I've probably done 8,000 or 9,000 competency evaluations of my own. And competency to stand trial refers to how is someone today? Do they have a rational and factual understanding of the proceedings against him? And can they consult with their lawyer with a reasonable degree of rational understanding? And then the state of Florida said there's 6 additional things. Does someone know the charges against them? Do they understand the possible penalties? Do they understand the adversary nature of the legal process, meaning who's with them, who's against them, who's neutral? Can they behave themselves in the courtroom? Can they testify relevantly? And then can they relate relevant facts to their attorney? So now if someone has no memory for an offense, that could be a problem in relating facts, and it goes to whether other things can be reconstructed. But as I read Dr. Kropp's report, there was no mention that Mr. Colley lacked the ability to relate relevant facts to what happened to his attorney. That's a key point of competency right in the Florida law. So based on Dr. Kropp's report, there was no reference to snapshots, memory impairment, blackouts, nothing like that. And no mention by Dr. Kropp that there was a concern that the defendant couldn't tell his lawyers about what happened. It's not there November 2015, less than 90 days after the shootings. It's not until years later that we hear, and I heard, I only remember this, it's like a snapshot, then I don't remember things for a while. We didn't start hearing that till more than 2 years after the shootings.
Did you also review some psychological testing that was performed by Dr. Mark Mills?
Yes, I did.
And what was, and I don't know that we, when he testified yesterday, that we heard any information about that. what type of psychological testing did you understand and review that Dr. Mark Mills performed in his evaluation of the defendant?
Dr. Mills did 2 broadband psychological tests. And they can either be done on pencil or paper or on a computer. One of them is the MMPI, or Minnesota Multiphasic Personality Inventory. He gave him the 2nd edition revised form, which is a little shorter. It's 338 true-false questions. And as people answer these questions, it generates a profile. And then that pattern of responses is compared to the thousands of people who took the test before, and it gives you hypotheses that people who answer the questions in this way, this is what they tend to be like. So no testing is 100% accurate, but the test is a very good one. It's been around a long time, and it generates these hypotheses about people's mental state and psychiatric disorders and their personality. It also has internal measures of validity. In other words, it's a cleverly designed test. It can tell you, is someone just Christmas treeing it, just answering it at random? Are they reading the questions? Are they trying to exaggerate symptoms and make themselves look worse? Are they trying to portray themselves as perfect and having no problems? So it not only does it give you ideas about people's mental state, it lets you know if they're answering the test questions consistently and appropriately. He also did a 2nd test, the PAI, the Psychological Assessment Inventory. Again, several hundred questions, and I think you can answer it: agree, partially disagree, disagree. So they cover much of the same ground, and it's a way for someone to take a test. It generates these hypotheses, and then you see, is it consistent with the other information we have? Is it consistent with our interview? And these psychological tests are useful tools. You can either use them in your practice, or they're very helpful in forensic cases or criminal cases. Is someone reporting accurately, or are they exaggerating or minimizing?
And is it correct, Dr. Danziger, essentially these tests sort of give you an idea of a person's sort of psychological profile, their personality, things of that nature?
It is, and again, I can't just do a test on someone and say I'm done. You have to look at the psychological test. How does that fit with the face-to-face interview with the person? How does that fit with any medical or mental health records? So it's part of an overall assessment. But with that, yes, it gives you helpful clues about people's psychological state.
And did you go through that process that you just talked about? Did you review that information, the results of those 2 psychological tests, as well as kind of compare that to your own evaluation of the defendant when you met with him?
Yes.
Okay. And can you tell us, were there anything in particular about either one of these tests, either the MMPI or the PAI, that you thought was relevant to this question of what was going on in the defendant's mind? What was his state of mind at the time that he committed these crimes?
Judge, I'm going to object at this time. The testing that occurred this year has no relevance as to the issue that's at hand and pertaining to this witness, so we object on relevance grounds to the issue of impairment overall.
The PAI picked up the alcohol history. He acknowledged problems with the use of alcohol. He acknowledged environmental stress, not surprising in 2017, being incarcerated. Some depression and difficulties in controlling anger. So the diagnoses, the hypothetical or hypotheses diagnoses on PAI were alcohol dependence and personality disorder. On the 2nd edition revised MMPI, the emotional findings included anger, ideas of persecution, and substance abuse. And the testing was suggestive of a person who was anger-prone, irritable, and had low frustration tolerance, and also had persecutory thoughts of others. So the suggested diagnosis was an anger-related disorder substance abuse problems, and persecutory ideas. Again, this was all from the testing done by another doctor, not by me, but I looked at the raw data and the test results.
And I want to talk very generally about this, Dr. Danzinger, but was there other information that you reviewed and considered with regard to other instances of violence on the part of the defendant?
Judge, we maintain our objection previously stated on the record on this issue.
Yes.
And let's just kind of walk through it. How many instances of violence, with regard to the information that you received and reviewed, how many instances of violence did you look at?
Judge, we object based on the court's ruling. This is inadmissible.
I'll sustain that objection.
Were there instances of violence that you reviewed?
Yes.
Okay. And can you tell us the dates that these occurred?
Objection for the same grounds. He's getting in the back of it.
Was there other information that you reviewed, Dr. Danzinger, that indicated that at the time that the defendant committed these crimes, that he actually knew what he was doing? That this was sort of a rational decision that he was making?
Yes.
Okay, and can you tell us about that?
We know that immediately after he fled the scene, which would be suggestive of someone trying to avoid being apprehended, that statements were made, "I'm not going to prison." This is suggestive of a knowledge that what he had done, that he had committed a crime, that he was at risk of going to prison and fleeing the scene to avoid apprehension and being captured. And I understand ultimately he was captured later that day in Northern Virginia, several states away. We know that morning a testimony already came out that he had ransacked the house and damaged television sets. So there was aggressive behavior to property just half a dozen hours before the shooting. And that, of course, is a factor for being in an agitated, aggressive state to property, at least. So all of those factors, as well as his ability to be armed and have firearms with him to commit the murders, all of this is worrisome behavior and suggestive of someone who's behaving purposefully and then aware of the wrongfulness of his conduct.
Let's kind of walk through your evaluation of the defendant. He kind of walked you through sort of a storyline of kind of what occurred this day, correct?
Yes.
And I know we already talked about some of the things, particularly the court, being in court and things like that. Can you just kind of walk us through and what did the defendant tell you concerning his actions, starting, say, the night before and all the way through when he basically fled the area to Virginia?
Sure, I'm going to go off my notes if that's all right.
Yes, sir.
He said that the day before he went to work, it was a normal work day, a solid day, 8:30 to 5, no issues at work, left work 5:30. Mother and father picked up Trey, his son, it was his birthday. We went home. Mother and father took him, we're hanging out on the porch. I tried to call Amanda, she did not answer. She texted, she wasn't feeling well, she was sick, and said, "Tell Trey I love him." I thought it odd, but I bathed and put the kids to bed about 9:30. I asked him if he took any medications, maybe a Lorcet, one of the pain pills, a few hours later. He said, "I'm having a drink of Crown Royal, 2.5 ounces of stiff drink." His friend Daryl called, he's at the bar. I go to the bar, mother and father with the kids. I meet Daryl. We had a few more drinks. I'm drinking socially, 4 to 6 more drinks. Left the bar about 2 a.m., bar closed. Driving home without incident, don't get pulled over. He then said also did a line of cocaine, maybe one at 12:30 in the morning, maybe one at 2 a.m. Last drink was just before 2 a.m., closing time at the bar. Drove Daryl home, had one drink at his house, was going to drive to Rhonda's, his sister's house where he was living, but didn't make it to Rhonda's. I went by the marital home to check on her, Amanda. She had said she was sick and thinking maybe we'll have sex. I get to the marital home, I use the garage door opener and my key because I'm able to come and go freely. No one is there, her car is gone, her dog is not there. He wonders, did she go to the hospital, but the dog isn't there, so he thinks something's up. I look around, the bed is made, and he found a box of S&M sex gadgets, saying we'd never done anything like that before, and 2 men's polo shirts that were not his size and not his logo. He said he's intoxicated and upset and broke the television sets. He then drove over to where he was living and went to see his friend Mike Dickens, who he said was 4 houses down and across the street. And he showed Mr. Dickens the gadgets and told Mr. Dickens, I'm not crazy, she's having an affair. Mr. Dickens told him to go home, so we went back to Rhonda's house where he was living. I called my wife on the way, told her I was at home now, what I found. She said it wasn't what it seemed. He apologized for breaking the televisions. He's back at Rhonda's house where he's been living. He knows he has court at 9 in the morning. It's close to 6 o'clock. He took a whole pill, which was 2 halves of the Ambien for 10 milligrams total, slept for about 2 hours, and his father woke him up at 8 a.m.
Let me stop you there because I want to ask some questions about the Ambien. Can you tell us, Dr. Danzinger, what is the recommended time that you would take something like Ambien? What's its purpose? What would be the recommended time? And then I'll ask some follow-up questions from there.
Sure. Ambien is a sleeping pill, and its general use is to put people to sleep. The immediate release Ambien is best at putting people to sleep if you have what we call initial insomnia, you can't fall asleep. It has a short duration of action. It has a short half-life, about 2 to 3 hours, and it's not all that effective after about 3 hours or so. Now there's an extended release or time release Ambien called Ambien CR, which if people who have trouble staying asleep, they may take that because it releases some of it immediately and then it's time release. It releases some of it throughout the night. But he took the immediate release Ambien, which is basically designed to help put someone to sleep. That's its best purpose. And it generally acts quickly within about 15 minutes when it works. So usually we tell people take it when you're expecting to get a decent night's sleep. I would admit I wouldn't tell someone to take it if they had to be up in 2 hours. I would admit that. So generally we tell people to take it if they're going to get a full night's sleep. And what I tell my patients is, don't take an Ambien and then say, let me run to the 7-Eleven to pick up some milk. And I also warn them if they're smokers, don't take an Ambien and smoke a cigarette. I don't want you passing out and setting the house on fire. So I warn my patients if they're smokers and they're on Ambien. So generally it's short acting to put people to sleep.
So it would be something that you would take if you knew that you had, you could get a full night's sleep, correct?
Yes, and sometimes what I tell folks is, it's best if you don't take it every single night because then it tends to lose its effect over time. And when you try to get off it, you may have trouble. So I'll tell people to take it occasionally or intermittently, or if they're lying in bed 20, 30 minutes and they're staring at the ceiling, okay, then go ahead and take it. So I try to encourage them not to take it every single night, but sparingly and occasionally.
So he told you that he went home and took 2 half tabs of Ambien?
Yes, that was his self-report. hours.
Okay, and at what time did you say?
About 6 a.m. was what he told me.
Okay. And so he goes to sleep, and how long did he say he slept for?
He said that his father woke him up at about 8 a.m. These are approximate times.
Okay. And then what did he tell you happened from that point forward?
He said that his father took the truck because it had the car seats for the kids.
Just 1 second, there was a question I forgot to ask you, pardon me. I want to go back to his father waking him up. Did he say how his father woke him up?
He didn't describe that to me other than father woke me up.
Okay.
He didn't expound on that.
Okay, I interrupted you, so go ahead. What happened from that point forward?
Okay. He said that father took the truck because his truck had the car seats for the kids, so he took his sister Rhonda's car. Now, he said he doesn't recall driving to court, and he said he was told later he hit a mailbox on the way that he doesn't recall it. He said that he took his morning medications, which was Flexeril, the Lorcet, ibuprofen, duloxetine, and left the house about 8:30. He also took some nutritional supplements. I asked him if he remembered court. He says he has a few memories. There are what he described as moments of clarity, a few seconds to minutes. He said they're brief clips, not still images. He remembered his lawyer saying he needed a form, and his father came in with a form. He remembered the judge ruling favorably, and his next clip was he's hugging his lawyer in the courtroom, and it's about 9:30. He then recalled his talking face-to-face with his father, but doesn't recall the conversation. He's in the parking lot outside the courthouse with his attorney, and he remembered leaving the St. John's Courthouse on Lewis Speedway. He told me then he recalls remembering I have to change, I have to get my work clothing, my badge, my gym clothes for a lunchtime workout.
So let me stop you there. So he told you that he was not, when he went to court, he was not dressed for work?
That's what he told me.
Okay, all right, go ahead.
So he needs to get his work clothes, his lunchtime workout clothes, a bag lunch. So he planned to go over to Rhonda's house where he'd been living, but he said he doesn't recall driving over there. And he got home to Rhonda's. He remembered speaking to Amanda on the phone. His recollection is it's 15 or 16 minutes, but he's not sure. She told him he was overacting. He said he was still going to move forward with the divorce. Her reply was, "Give me time, don't do that." And his recollection is that she said, "If you stop the divorce, put it on hold, I'll move out, you can have the kids full-time at the home." That's what he remembered hearing from Amanda.
Was there any, did he mention anything to you in that conversation about the police being called to the home in relation to him breaking in the night before or anything like that?
Not till his second phone call.
Okay, was that what you were going to next?
Yes.
Okay, go ahead.
He then said there was another phone call at around 10 a.m. Again, these times are approximate. And she, being Amanda, said the police are here. He wanted to clean this up and make it better. And this is what Mr. Colley said. I asked her not to tell the policeman about the television. She said, "I won't." He said, Mr. Colley said, "I thought you said you weren't going to call the cops. I'll pay for it." Her reply was, "I didn't call them." And she said, "I'm trying to fix this, James," and hang up. So what she said was, told him the police were here, and we know it was a public safety officer. He says to her, "I thought you said you weren't going to call the cops." And her reply was, "I didn't," which is true. She was not the one who called them. And she said she's trying to fix it.
Okay. And what the next part of his story to you?
His recollection to me was, I start panicking. The cops are going to arrest me. I've got to run over there and give a check to cover the damage. And I asked him how far it was. He said it's 7 or 8 miles. He said he had little memory of the drive over. He got there and recalled parking behind the house on the street behind it in case the cops showed up. So he remembers getting out of the car. He said he was not armed. He said there's a little hill between the yards. He's coming from the street behind it. And he said there's a jogging trail behind the house. And he can see into his house. He's looking into the rear of the home through a sliding glass door. And he sees what he thinks is his wife, and behind her he sees what looks like a man. He remembers not being able to breathe and seeing a man. I saw little black specks. I was lightheaded and I felt faint. I bent over and felt nauseated. And he said, it hit me, don't faint here and have the man find me. He felt that he needed to go. His memories are spotty, but he remembered walking on the little hill and dry heaving. And he then says he has no memory until he's behind the house on a jog trail armed with 2 semi-automatic handguns.
Did he talk to you about going back to the car?
He did not. When he spoke with me, he did not have a memory of going to the car. He said, the last thing I remembered, I'm walking back, I'm dry heaving. The next thing I remember, I'm on the jogging trail and I've got 2 semi-automatic handguns.
All right, go ahead, doctor.
I asked him his next memory. I see through the picture window. I remember shooting at the picture window on the right side of the window, knowing they are to the left. He doesn't remember saying or yelling anything. He remembers running to the window. He said his next memory, I'm in the bathroom, I've got the gun in hand, I'm screaming, my ears are ringing. He remembers saying, where is he? He said his wife is looking at him, she's screaming, he's not here. He says, I saw him, I think he's in the closet. And she says, put it down and give me that, holding out her hand. He remembers trying to get in the closet, and then he remembers going in the closet and it's dead calm and quiet. He then says there's a blank period. He's walking across the backyard, gun in hand. He says to himself, pardon my language, oh shit. I asked him, did you have any memory of shooting anyone? He said no. He said, I assumed I shot Amanda. I didn't think or know I shot anyone else. He doesn't recall driving away. He said his next memory is he's back in Rhonda's area. He heard on breaking news 2 women were shot in the Maribel neighborhood, and he remembered feeling scared. He does not remember a phone call with his father. He stopped by Rhonda's house and he grabbed an AR-15 rifle. Then there's a period of blank. He said, I remember my father screaming at me what happened. Mr. Colley said, I'm putting the rifle in my car. My father's asking me what happened. I told my father, I think I shot Amanda and her friend. The father said, get out of here, son, we'll work this out. He gives me money, go to Donna's in West Virginia. He said the blackouts grow longer. I don't remember driving up there. There's flashes of being pulled over for erratic driving. And then he summarized it later saying, I went over there to pay for the TV. I had my checkbook at the house, assuming the marital home. I saw a man there. I assumed it was her lover. I felt a panicky attack. I don't recall anger, instead scared. I was angry when I was looking for him. I don't remember crossing the yard except for a split second. I don't remember yelling from the yard. He said, I just don't know, it's not clear, it's choppy, it's all I have.
Obviously, his self-report, doctor, is different than the opinion that you have testified to today, correct?
Correct.
And how do you reconcile the statements that he made to you during your evaluation and the different opinion that you've reached in this case?
Several factors. First, Dr. Kropp said he told me what happened after court. 10 weeks after the offense, November 2015, No references to choppy memory, still pictures, video clips, long periods of blackout. It's not there. And then we have something here that's very unusual in a case like this. Less than 90 minutes before the murders, he's in court where there's an audio and video. So we know what his mental state was like 60 to 90 minutes before the shooting and closer in time to any drug effects. If someone was under the effect of a drug, you'd expect to see it closer in time, not after the fact, especially a short-acting, immediately dissolving drug. And what do we have in court? It's perfectly coherent, logical, rational. Judge doesn't have concerns. His own defense lawyer doesn't have concerns. He comes up with these spontaneous ideas about taking the bond money. How can I get my probation terminated early? He knows exactly how much he has to go with the batterer's intervention. He's clear, coherent, and logical. So trying to say that 60 to 90 minutes after that there's some drug effect, it doesn't make sense.
Everyone, sure. No further questions.
Mr. Wood, how long do you anticipate your proclamation?
Maybe a little bit, I don't know if that makes a difference.
Let's go ahead and take our afternoon break at this point, folks, before we get into cross-examination. What Dr. Danziger, it's almost 2:30, so let's plan on being back and ready to come back at 2:45. And again, don't discuss the case among yourselves or with anybody else during the break. Now, when you research, leave your notes here in the courtroom. 2:45, be back in 3. Everybody else remains. Y'all can be seated and remain in the courtroom until the hearing is out of the hallway. Dr. Danziger, you remain on the witness stand, so don't talk with anybody during the break. You're free to go about with whatever during the break. Just don't talk with any of the lawyers or anybody else for that matter during the break. Of course. And this will give the state an opportunity to check on Judge Timlin, see what his status is. Communicate he has a calendar going on, and we'll check on that. All right, we'll be at recess until 2:45.
courtroom.
Everybody is ready to break. We're ready to continue. Begin with the cross-examination of Robert Danziger. You may proceed with order.
Good afternoon, Doctor.
Mr. Wood, good afternoon to you, sir.
Now, let me kind of go for the moment from a little bit of a reverse order, starting towards going towards the tail end of your direct examination. You're talking about Dr. Kropp and his evaluation of Mr. Colley, his involvement in this case. I believe you said that you received his evaluation of this case dated December 30th of 2015, is that correct?
Yes.
Okay. And in that letter or that report to Mr. Shoemaker, Terry Shoemaker, in the first paragraph of that report, Dr. Kropp says that he's providing a summary of his impressions in the case. Is that correct?
Yes.
Okay. So, and then further into the that report, Dr. Kropp gives an opinion that he believes that Mr. Colley is competent to proceed. Is that correct?
Yes.
Okay. Now, in that same paragraph, in that same report, he does also say, however, given the various medications he was taking, I would recommend that a psychopharmacologist review the defendant's drug use around the time in question. Is that correct?
Yes.
Okay.
Which indeed happened here.
And have you, in your prior history as a psychiatrist, consulted with pharmacologists or psychopharmacologists?
Yes.
And is that something that's characterized as something that's fairly often done in your practice, or how would you characterize it?
If there's an issue, for example, regarding to urine or blood testing, which was not a factor in this case, but then it's helpful to talk to a toxicologist or pharmacologist. If there's a question of interpreting autopsy results, for example, that's usually not something a psychiatrist would do. If there's something involving the metabolism of drugs or very rare drug effects, then it might help to talk to someone who's a pharmacologist or a toxicologist. So not in every case that I've done do I consult on that. And in my day-to-day practice as a treating doctor prescribing medications, I don't call up a pharmacologist. I mean, I understand enough as a practical day-to-day doctor how to prescribe these drugs, what the side effects are. But there are situations where it helps to have a consult.
Now, from your review of this report, are you left with the impression that Dr. Kropp is indicating that he'd like to have additional materials to be able to review in the future in his involvement in the case?
Well, my impression was my own, that he got a full account of what happened after court, and he's saying that the issue of drug effect is not something I do. Maybe drugs had an effect on Mr. Colley, and my recommendation to Mr. Shoemaker, the lawyer, is get someone else to look at that. That's my reading of it. Of course, I'm not Dr. Kropp, but that's how I understood what he wrote.
And as your involvement in this case, or during your involvement in this case, did you ever consult with Dr. Kropp regarding this case?
No, I did not.
Do you have any idea how long Mr. Colley spent with Dr. Kropp?
I don't.
Okay. Obviously, you were not present when this consult or evaluation was done with Dr. Kropp.
No, I had no knowledge of this matter in November or December 2015, not at all.
Now, from your review of the report of the writing, the document from Dr. Kropp to Mr. Shoemaker, the focus is competency to proceed to trial. As you say, that's issues of whether the person has a mental defect which prevents them under the legal standard from being able to assist their lawyer in their own defense.
Well, not quite, because Dr. Kropp also addressed sanity and said that Mr. Colley could appreciate the nature, quality, and wrongfulness of his conduct. So he addressed both competency and sanity.
Are you aware of any testing that Dr. Kropp did on Mr. Colley?
No.
Okay. All right. And do you know, would you have any way of knowing if Dr. Kropp's practice in conducting competency evaluations are shorter or longer, more involved, less involved than if they're an evaluation for insanity at the time of the offense? Would you have any way of knowing that?
I don't know how Dr. Kropp does. I don't know how I do it, but that there's two factors. First, some cases are more complex than others. Secondly, a capital murder case probably takes more time than a trespassing case because the stakes are higher and there's often more information to sort through. So some people are more talkative than others. So there's different factors that affect how long it takes. But typically, my understanding of Dr. Kropp, and he can speak for himself, but it appears to me he looked at the issue of what is Mr. Colley's competency, his current mental state, as I talked to him 3 months after the offense, and what was his mental state like at the time in August. So it looks like Dr. Kropp addressed both.
And this was the only report, only document referencing a consult that Dr. Kropp had with Mr. Colley.
It was, but again, the key thing was there was no reference to memory impairment, blackouts, or fogs. There was no reference to that. Dr. Kropp simply said he described the events after court.
When you were retained in this case, what is your hourly rate?
For this case, I cut it in half. It is $300 an hour.
Okay. So normally it would be $600, it's $300 an hour for this case.
Correct.
Is that because you're being retained by the state attorney's office?
No. If I'd been retained by a public defender, I would have done the same thing. So if it's the public purse, I usually cut my rates at least in half.
Okay. And do you know?
You are not a public defender.
That's correct. Do you know thus far how much you charged the public purse for your involvement in this case?
So far, the bills that have gone out are about $7,400. Of course, I did some preparation time last night, and then I've been here today, so that will add to that.
Okay. All right. Now, in your practice, your psychiatric practice, have you had, certainly you've had patients in the past that have expressed issues, problems, if you will, with side effects of the medication that they're on?
And the answer is yes. You're a doctor in practice, you prescribe medications. Some of these medications have common side effects, so yes. And in fact, if I see patients in follow-up, if I prescribe something, the first time I see them, I ask about the effect and any problems with the medication. So I actually ask if they're having side effects. And sometimes people will call me after starting a medication saying they're having an issue or a problem. So yes, it's very common in day-to-day practice.
And have there been occasions when you've had to adjust medication? And when I say adjust, either take him off that medication, put him on a new medication, or change the dosage in any way?
And the answer is routinely. That's a very common thing in practice.
Okay. And have you done that type practice or habit in with regard to antidepressants?
Yes, one of the major classes of medications psychiatrists prescribe are antidepressants because they treat depression and anxiety, which is what drives most people to my drug.
And you were able to hear Dr. Buffington's testimony with regards to his testimony regarding the effectiveness, say, for Wellbutrin, that it takes a while for that prescription to reach its peak effectiveness. over time once taken?
I listened, but I have some disagreements with his analysis.
Now, and he also spoke about Cymbalta. Is Cymbalta a more potent drug than Wellbutrin?
No. Each antidepressant is equally effective in the treatment of depression. None of the antidepressants we have are more powerful than one another. They may work for different people. Some medicines better for others. Their side effect profile may differ. But to date, we don't have an antidepressant that's our most powerful or better one. They all seem to be equally effective, although they may work for different people.
And you're aware of the side effects for, adverse side effects for antidepressants?
I'm sorry?
Are you familiar with the adverse side effects for Wellbutrin and Cymbalta?
Yes, these are medications that I actually was a principal investigator on before they even came out on the market. I've used Wellbutrin since 1988, before it was approved. Cymbalta, duloxetine, since the mid-90s, before it was approved. I've prescribed these medications to hundreds of patients, written thousands of prescriptions because some patients stay on it and need further prescriptions. These are very commonly used medications that I've prescribed thousands of times.
And you reviewed, during the course of this case, the listed side effects, adverse side effects that Dr. Buffington related in his materials about Ambien?
Yes, and again, I prescribed Ambien, which came to the market in 1990, 28 years ago. So I'm very familiar with Ambien. I've written prescriptions for it. I have patients who take it. So I'm familiar with the side effects, not just from what Dr. Buffington wrote, but because as a doctor, I've been writing it for almost 3 decades.
And you don't have any disagreement with Dr. Buffington's documentation as to the listed known adverse side effects of Ambien?
Not the known side effects, but its relationship to this case. That is the distinction. I agree those side effects can happen. I disagree it happened here.
So in the testimony, and to extend that question out, with regard to the adverse side effects that Dr. Buffington testified to in this case here today, you don't disagree with the testimony as to the adverse side effects?
I don't disagree with the hypothetical or possible side effects you can see. If you put, as we do in our studies, thousands of people on this medication, and then you see how many people had headaches, how many people were sleepy, how many people were coughing, how many people had diarrhea. So you put thousands of people on it in the studies and you have the percentages. So there are more common and rarer side effects. I don't disagree with the side effects he listed, but just because it's listed and it may occur at 1 or 2% in thousands of people, it doesn't mean it occurs in this particular person. And our disagreement is whether it happened in Mr. Colley's case. I say it didn't.
Now, you're aware of the literature and the research with regard to adverse side effects of Ambien, are you not?
In general, yes. I can't cite a specific paper, but yes, I prescribe Ambien. I'm aware of the side effects. When I prescribe it for a patient the first time, I give them informed consent saying these are the potential side effects. If this happens, call me and stop taking it. So yes, I discuss this with patients the first time I put them on it, what to expect, what problems they might have it, when to call me and not take it anymore. So that's just part of the day-to-day being a doctor practice.
And you're, I think you alluded to it a little while ago, but you're aware of, in the literature and the research, of situations where persons have completed complex tasks, driving, other types of activities, while they're experiencing the adverse side effects of Ambien, correct?
Driving, but usually driving poorly and being confused when spoken to. So they may engage in a task like cooking or driving, but they are not fully coherent and organized. There's a distinction. But you're correct that they can drive, but often drive poorly.
The parasomnia that was described earlier today, and defined here today by Dr. Buffington, and actually, well, you were here yesterday, it's an unfair question. Do you have any disagreement with Dr. Buffington's definition and description of what parasomnia is?
I don't recall exactly what he said, but I know a parasomnia can be described as some unusual event or experience during sleep.
And do you know that parasomnia also to involve memory loss?
Yes, and there's many parasomnias: sleepwalking, sleep terrors, REM sleep disorders, exploding head syndrome. There's all sorts of sleep paralysis. There's all sorts of parasomnias. Some of them people remember, some of them they don't.
Do you, let me go back to something you said kind of in the earlier stages of your direct testimony, which was one of the things that you took into consideration with regard to the issue of impairment is that Mr. Colley, on the days prior to the weeks, consisting of the week prior to the shootings in this case, that Mr. Colley went to work and there was no reported adverse effects with regard to the medication during that week prior to the homicide. Did I succinctly state that's what you talked about?
More or less, and that was in response to Dr. Buffington talking about the changes in antidepressants producing problems, and my response was he was going to work, he was coaching t-ball, he was enjoying birthday parties, doing recreational things. So whatever changes were made in the antidepressants did not appear to affect his day-to-day behavior in the days and weeks before.
And did you ask Mr. Colley when you did your in-person evaluation with him whether or not he had been taking Ambien on the days or any specific day prior to the morning of August the 27th, during that week time frame before the murder?
I don't believe I asked that question.
Okay. So now I think you said this on direct, you did receive Mr. Colley's pharmacy records and medical records, is that correct?
Yes, well, I received some pharmacy records and I received some medical records. So when you say that, I don't know if I had every single record, but I certainly had some medical records.
And to clarify, you did have pharmacy records indicating that Mr. Colley was in fact prescribed Ambien and antidepressants in August of 2015.
Yes, on August 10, prescribed by Dr. Sanchez and then picked up at the pharmacy. Exactly what he took, I don't know, but they were prescribed and he got them at a pharmacy. That's correct.
Okay. So you have no issue about whether or not Mr. Colley was in fact prescribed Ambien or the other medications?
That seems to be very clear, and there's no dispute on that point.
Okay. Now, are you familiar with forgive me, it's a layperson asking a psychiatrist a technical question. How long does these psychoaffective, how long does Ambien last in your system as far as having effects on the mind? I'm talking about blood tests. You know, if we were to do, like with cocaine, if you were to do a blood draw or something like that. But how long does Ambien stay in your system as far as affecting your state of mind?
The average duration of action is about 3 hours. Now, that's if you take the immediate release form, not the time release form that slowly dissolves over hours. So if you take an Ambien, it acts fairly quickly, it dissolves fairly quickly, and usually takes effect in 15 minutes. It's got a short half-life, which is the time for your body to eliminate half of it. Half-life's about 2.5, 3 hours. And typically its major effects are within the first 3 hours. So that's why it's good for putting you to sleep. It's not as good for keeping you asleep if your problem is you fall asleep fine, but you're up at 2 or 3 in the morning. So that's why they made a time-release Ambien, the Ambien CR, so you get half of it immediately and then the rest of it dissolves out over the next several hours to try to keep you asleep. But I'm not talking here about how long you can measure Ambien in the blood or the urine or anything like that. But its effect is fairly short. The major effects are within the first 3 hours.
Wouldn't the effect actually be more in the 8-hour range?
Typically, that goes to the point of why it's good to knock you out. It's good for initial insomnia. It's not as strong for later. So you can still probably detect it, but its major effects are in the first 3 hours.
Does that vary on the individual, or are we all cookie cutters as far as the effect on Ambien on the person?
No, everyone's different. Everyone's liver and kidneys works a little bit differently. Part of the roles of our liver and kidneys is to break down or metabolize medications and eliminate them. So when you take a medication, your body works to eliminate it. So the liver does a lot of that heavy lifting, so do the kidneys, and everyone's a little bit different. Everyone's liver enzymes are a little bit different. Everyone's genetics are different. So how quickly we break down drugs, it varies from person to person. There's averages. Some people are outliers.
Let me ask you this. When you testified about the narrative, your interview with Mr. Colley and his description of the events in question, did during the time that you were with Mr. Colley there at the jail doing your evaluation, did you make the effort to distinguish between what was told to him from others or what he read from other sources versus what he remembered?
Sometimes, for example, the mailbox. For example, he said he didn't recall hitting the mailbox, but was told that. But when I was speaking with him about his recollections, I was asking him, what do you recall? Not what other people told you.
And you didn't,
with the exception of the mailbox, perhaps.
Right. But you didn't do that with every point that you were asking about. Is this what you remember, or is this what somebody told you? I mean, I was there with you. Did you make that distinction when he was reporting to you? Hey, is this something what somebody told you, or this is what you remember?
I know that during his report of what happened after court, I was asking him, what do you remember? That's what I recall. Of course, there was no court reporter there. You were there, and Mr. Shoemaker was there. My effort was at that point, what do you remember? How I specifically asked it, I don't know, but my recollection was, tell me what you remember. And that's why there's things where he said to me, I remember I was standing on the jogging path, and then my memories are blank for a while, and then I'm here, and then there's a blank. So my intention was, what do you recall?
Mm-hmm. I do not have anything else. Thank you very much.
Mr. Johnson, may we read your examination? Thank you, Your Honor. Is Dr. Danzig here excused? Yes. Dr. You are excused. Thank you. Thank you. Call your name, please. Give me a moment. Yes, sir. Okay. Steve, would you mind just round up this next witness? So we'll go ahead and take a short break. I'll have you stay up here if everybody here doesn't mind, because this will be very short as opposed to moving you back and forth to the other floor. So let's plan on about 10 minutes at most. And again, don't discuss the case among yourselves. Leave your notes here in the courtroom and get back with you as soon as we are ready. our next witness available. So state call your next witness.
State calls Judge Charles Tillman.
Judge Tillman, if you can come in. I know I don't have to tell you where the witness stand
You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Be seated. Ms. Dunn, you may proceed when you're ready.
Thank you. Good afternoon, Your Honor. If you would, please introduce yourself to the jury.
My name is Charles Tillman.
And how are you employed, sir?
I'm a county judge here in St. Johns County.
How long have you served as a county judge here in St. Johns County?
I'm in my 28th year.
And what types of cases do you preside over?
I do both a criminal docket and a civil docket. Probably majority criminal, but probably 35% civil.
How many people or cases come before you in your courtroom every year?
Last year, the numbers were about 7,000 cases.
And you said a majority of those are criminal cases?
They are.
In a criminal case, if a defendant wishes to enter a plea, what happens at that time? What do you do?
The defendant will be placed under oath. I'll ask the defendant's name, the defendant's age, occupation. I ask whether they've ever been treated for any mental illness, and I'll ask them if they're now under the influence of any intoxicants. I'll then explain to them that by entering this plea, they are giving up their right to have a trial, to be presumed innocent until proven guilty, to be represented by a lawyer, and if they cannot afford a lawyer, I would appoint one to represent them. That they have a right to cross-examine any witness called by the state to testify against them, to compel the attendance of their own witnesses, to testify or remain silent, and they would be presumed innocent until the state proves their guilt beyond a reasonable doubt. In some cases, there's a little bit more advisements. If it's an enhanceable offense, or if they lose their license as a result of entering a plea, there may be some additional admonishments as well.
And what is the purpose of asking a defendant those questions in a criminal case that we're talking about here?
We want to make sure the defendant is giving a free and voluntary plea, that he understands his or her rights to. They're guaranteed by the Constitution, the right to be presumed innocent until proven guilty. They're not being influenced by anything, that they're not under the influence of anything.
And are you looking for anything while you go through that colloquy with the defendant, and do you have to make any determinations at the end?
First of all, I want to make sure that they understand what they're doing. And I also want to make sure that they're not suffering from any kind of incapacity, be it mental incapacity or they're under the influence of anything.
And is this something you do on a daily basis?
Every day.
Have you had experiences in your past 28 years on the bench with persons where you do become concerned for one reason or the other over their ability to understand what's going on?
I had a case today where I was very concerned about the defendant's mental well-being. He was somewhat unresponsive. He wouldn't look at me. He kept looking at the floor. I couldn't get an answer from him. So I asked that he be evaluated by mental health to make sure he's mentally competent to go forward. That's not unusual. I've also had occasions where I believe someone might be under the influence of either drugs or alcohol. If I get an indication, regardless if they tell me they're not, I might have them go into a breath test machine, or maybe have them take a urine test and determine if they're under the influence of anything. I've had people that have in fact blown high blood alcohol level while they're in court while I'm trying to take a plea. And what I'll do, I'll remand them to custody possibly, or I'll reset them for another court date.
Now, I want to ask you about a plea that you took from the defendant in this case, James Terry Colley, Jr. Do you recall a court appearance with him August 27th of 2015?
I did.
And was that in your morning court docket there a little after 9 a.m., I believe?
That sounds about right.
Was he present with a counsel or an attorney at that appearance?
He was represented by a gentleman named Colley Grant.
Did you go through the colloquy that you just explained to the jurors with Mr. Colley that morning?
I did.
And throughout that process, did you have any concerns over impairment or his ability to understand?
I did not. I asked him if he was under the influence of any intoxicants. He told me he was not. There was no indication, nothing in his demeanor that indicated he was under the influence of anything.
Did you make any observations or findings about him after going through that colloquy?
I made a finding that he was competent to proceed, and I took the plea. His demeanor was fine. I didn't see any indication that he was swaying or not understanding the questions I was asking. He was giving me appropriate responses to the questions I was asking.
He was alert and intelligent and things like that to look for.
my opinion, he was.
And did he ask you relevant questions throughout the colloquy as well about what was going on?
He did. He seemed, his biggest concern that day was when he could be off probation. I explained to him that upon completion of all the conditions of probation, which would include a 27-week domestic violence course, he would be terminated from probation if he completed that successfully and paid all his court costs and fines.
Is that something that you get asked a lot by defendants entering the similar type plea?
Yeah, people want to know when they could be finished and if they can be off probation early, so they may ask that question, sure.
And Your Honor, prior to court, did you review an audio and video recording of that appearance that we've been talking about here today?
I did. I observed the video that you showed me, and I also watched one that I had on my computer drive after I found out I was going to be subpoenaed for this trial.
Your Honor, may I approach?
Yeah.
And Your Honor, I'm going to show you what's been previously marked as State's Exhibit E for identification. Do you recognize that disc?
I did. I initialed it today and dated it.
And that's the recording, or at least one recording of the plea colloquy that you took with the defendant on August 27th.
It is.
Your Honor, this time State would admit State's E.
Any objection?
Judge, for the reasons that we previously stated during another session out of the presence of the jury, we maintain our objection. We attended to the matters that we stated on the record previously.
Okay, so noted for the record, the objections are overruled and the item will be admitted into evidence. This is the State's next number exhibit.
Your Honor, permission at this time to publish?
You may.
You can call your next case when you're ready. Next case, Judge, is going to be James Colley. Come on, sir. He is charged with violation of injunction. Good morning.
Good morning, sir. I'll ask on behalf of James Colley.
Thank you, sir. And Mr. Veteran, do we have something worked out today?
Yes, sir, I believe we do.
Go ahead, please.
Your Honor, this time Mr. Colley is authorized me to enter a plea of no contest to charge of violation of injunction with the understanding that his sentence will be a withhold adjudication, 1 year unsupervised probation to agree to the battery intervention program, which he is already enrolled in, the standard court costs, and a suspended sentence of 60 days with 2 days time served.
Well, I don't have a problem with any of that, but my problem is if it's non-reporting unsupervised probation, who the heck's going to monitor this?
Your Honor, at that point, I believe if he doesn't complete or show proof to the state attorney or I assume the state attorney's office at that point, by the end of the year, that he would be in violation of that probation.
That all sounds good in theory, but Mr. Bird is my 25th prosecutor since I've been on the bench. I don't know if he's going to be here in a year.
Yes, sir.
So I don't know who's going to babysit this thing to make sure it's done. Yes, sir.
Your Honor, I will personally make sure that it's done. We are also handling a first case, which is where it's stemmed from.
Mr. Veteran, with that assurance, I'll go ahead and do what you're asking me to do. So ladies, this is going to be unsupervised probation. And Mr. Colley, you wish to enter a plea to charge? No contest? Please you raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth to help you out? Yes, sir. Put your hand down. Please tell me your full name.
Mr.
Colley, how old are you, sir?
35.
And what do you do for a living?
I am a auditor of the city bank.
What is your educational level?
I have an associate's degree in business.
Have you ever been treated for any mental illness?
No.
Are you now under the influence of any intoxicants?
No.
You told me that you wish to enter a plea of no contest to charge with violation of injunction for protection against domestic violence. This is a first-degree misdemeanor for which you could be jailed up to a year. You could be fined $1,000 for both, or you may be considered for a lesser sentence or probation. Do you understand that by entering this plea that you're giving up your right to have a trial on this charge, to be presumed innocent until proven guilty, to be represented by your attorney, and if you could not afford your own attorney, the court would appoint one to represent you?
Yes, sir.
Have you discussed this fully with Mr. Veteran, your lawyer?
Yes, sir.
And are you satisfied with the representation and legal advice he's given to you?
As long as I have legal advice, I'm okay.
Well, there's going to be some court costs involved. You're going to have to complete the battery intervention program, pay some court costs, have no violent contact, and if you don't do that, you'll be sentenced to 60 days in jail. Will the state please proffer the facts? Judge Stewart been able to prove that on or about July 20, 2015 through on or about July 29, 2015, and on various cases between July 20, 2015 and July 29, 2015 in the County of St. Johns, Florida. Defendant did intentionally unlawfully having no serve with an injunction for protection against domestic violence. Violated that injunction for failure to vacate the dwelling and will remain equivalent to violation of police action. Any objection to those facts, Mr. Bedford? No, sir. All right, the plea is accepted. Adjudication will be withheld, which means this is not a criminal conviction on your record. You'll be placed on 12 months of unsupervised probation with early termination if you complete everything earlier.
24 weeks in the Constitution.
What's that, sir?
24 weeks in the Constitution.
Okay. You've already signed that and
I've
started?
always signed up, I started with it.
Okay. So if you complete the class, get your court cost paid, you can be off this probationary period. And Mr. Bedford, upon completion, if you want to submit a termination to me, I'll be glad to sign that.
Yes, sir.
All right, the court cost in this particular case is $474. I'll give you 180 days to pay that, so you got plenty of time to pay it as a condition.
I have $500 bond can be used, sir.
Yep, we sure can. So that cash bond will be used, any balance will be refunded. So you're all paid up, so really all you got to do is class. Yes, for the third time. So in addition to that, you have no violent contact with Amanda Colley. All right. And this will be subject to a 60-day suspended sentence with 2 days credit for any time you serve. You'll have 30 days to appeal. If you decide to appeal, if you can't afford a lawyer, I'll appoint one. After you sign this, you will be fingerprinted for the judgment. The sentence will give you a copy. And Mr. Bedford, if you will submit to me a termination of the probation along with a copy of the certificate of completion, I'll be glad to get that signed for you.
Yes, sir, and just for the court's knowledge as well, the case that this is derived from, there was a permanent injunction entered and he is required to do this VIP course, so he's got 2 incentives to complete this course.
Well, now in the injunction, is it a no violent contact or is it no contact?
I believe it is a no contact period.
No contact.
There is a specific provision and mirrors what was placed in his bond condition. They have children together. They are allowed to communicate for the children. However, that particular injunction does prevent him from having contact unless it's in regards to the children.
Well, obviously there's no violent contact as well, but if he violates the conditions of the injunction, that's a separate criminal charge. He can also be charged with and held in contempt and sentenced to 179 days in jail for a contempt charge. So I would suggest you abide by the conditions of the injunction, and as long as you abide by that, that won't be an issue in this particular case. Come on and sign this, sir. Mr. Bedford, is all you have?
That's all I have, Your Honor.
Thank you. Good to see you.
Thank you as well.
Thank you, Your Honor.
You're welcome, sir. Next case?
Next case, Judge, Michael Fairbanks.
All right, you can call you.
No further questions, Judge.
Mr. Wood, any cross-examination?
I do have some. Good afternoon, Judge.
Afternoon, Mr. Wood.
Good to see you as well.
Thank you.
Let me go through some questions with you about that particular day. It looked like there were some folks that were in the, for lack of a better phrase, in the audience. Was it fair to say that you had more than one case going on that particular docket?
It was a very light docket, but there were other people in the courtroom, yes.
Okay. Now, I'm sure the jury has never witnessed that your plea colloquies and your proceedings before is the time frame for this particular plea. Is that about kind of the normal time frame for a plea dialogue?
Pretty standard, yes.
Okay. Now, I don't know if the jury could hear it or not, but you said something to Mr. Colley in response to something he said for the third time. Yes. What was he talking about there?
He asked me 3 times if he could be off probation upon completion of the classes. That's the 27-week batteries intervention program.
Okay. All right. Now, you talked about in direct examination, there have been times when you've had defendants take a breath test, when you've suspected that there's some impairment there, would it be fair to say that those are occasions when there's an outward appearance of impairment that rises some concern to you about the ability of the defendant to understand the proceedings?
Sure.
Okay.
Whether it's the way they're talking, the way they're fidgeting, the way they're responding to my questions, the questions they may ask me, it may give rise to suspicion they're under the influence of something.
Now, where Mr. Colley was standing during at the podium there for the plea dialogue, is that the usual distance? I mean, they don't ever get close enough to you than that when they're doing a plea dialogue in your court, is that correct?
No, I have them stand at the podium, and the distance between the podium and where Judge Moss is sitting is about the same as it would be in my courtroom.
Okay. Now, so if someone had come to court and had consumed, controlled substances prior to coming into your courtroom, you would not know that unless you saw signs that rose some concerns in impairment issues. Is that correct?
That's correct.
I mean, because otherwise you wouldn't, drug test them. You wouldn't have any reason to do a breath test on them unless you saw something that was suspicious. Is that correct?
That's correct.
Okay. So you would have, for this particular case, you would have no way of knowing, based on your observations, whether or not Mr. Colley had in fact taken a controlled substance like Ambien before he came to your court.
I saw no outward signs that he was under the influence of anything.
And I mean this certainly with all respect, but do you have any training in psychiatry, pharmacology, anything like that?
I don't, just human observation.
I understand.
And I see a lot of humans.
Yes, sir. Thank you. All right. I don't have anything else. Thank you so much, Judge.
My pleasure.
I redirect this time.
Hey, Ron.
Is Judge Tinley excused?
He is.
Judge Tinley? Stay. And you'll be done with your rebuttal.
Yes, sir.
Okay. So we're going to go ahead and break a little early today, and then there'll be one more rebuttal witness tomorrow morning. Let me talk about tomorrow a little bit with you. It appears that we're going to finish all the evidence and testimony relatively early tomorrow. What's going to happen after that is the lawyers will give you their closing arguments, and then I'll give you the final instructions you need to follow in determining your verdict in this case. If it's around 2 o'clock or so, I'll give you the case to deliberate tomorrow afternoon. If it gets much later than that, then it will be the next day. I don't anticipate we'll have a problem getting it to you tomorrow to deliberate. With that in mind, the same rules are going to apply that applied once we're at the end of the first phase of the trial. Should the jury be unable to reach a verdict after the first day of deliberations, you would have to be sequestered overnight. So I will ask that when you come in tomorrow, we'll have that same parking arrangement that we had last time, that same spot with the deputy with your car, keep an eye on your car. Also bring a bag, an overnight bag, in the event that it becomes necessary that you have to stay overnight for an overnight sequester. And I will let you deliberate for as long as you need tomorrow, and then if necessary, obviously the next day, as long as you need to, obviously you can rush on that. Same thing with regard to the phones, tablets, and electronic devices. You can't have those with you when you deliberate. So if you want to leave them in your car tomorrow morning, of course you can do that. But if you want to bring it with you as well, that's fine. And then we'll have a deputy that will be able to secure that while you're deliberating. So that'll be the directions for tomorrow morning. Hopefully, if everything runs on schedule, I'll be able to give you this case to deliberate sometime around 2 o'clock. And like I said, if it gets much later, then we have to bring you back Thursday to do that, but I hope that doesn't happen. Let me give you the same instruction that I've given you every day for the last couple of weeks now. Don't discuss the case with anybody overnight. Don't do any research of any type. And please don't watch, listen to, or read any media accounts of the case overnight. We'll ask you that same question in the morning. And you'll need to leave your notes here in the courtroom. So with that, I wish you a good evening. Tomorrow morning, 8:45, same time, same place, 30 miles. We'll see everybody in the morning. Have a good evening. reflect we're outside the presence of the jury. All parties present, including the defendant. So let's take a little time this afternoon while we have some time. Okay, sending the jury home early, but I'm not going to send you all home early. So we'll take advantage of this time to talk about jury instructions. If you all need a moment to bring them up on your computers.
On our proposed penalty phase jury instructions, having the court make your decision as to those objections. We'll stand by those as we go through this. I don't want to say anything that indicates I'm waiving anything from you.
Okay, let's do this. I'll note a standing objection to the instructions as a whole, based upon what you earlier submitted, which are the redactions and additions and so forth.
Yes.
But then I'll understand if you don't say you don't have an objection to a couple of paragraphs in here, or all paragraphs for that matter, you're not waiving your earlier objections because you have a standing objection to the instructions as a whole. All right. Other than the standing objection, any objection to the first paragraph?
No, you won't.
All right. The second paragraph is called the Hurst v. Florida paragraph. But the jury has to make a unanimous determination as to each aggravating factor alleged by the state, and they have to determine that beyond a reasonable doubt, and defines in general an aggravating factor. Any objections other than those previously noted to that paragraph?
No.
All right, then the state goes through the aggravating factors for count one. The first one listed is the prior conviction of another capital felony or felony involving use or threat of violence to another person. That then goes on to state that first-degree murder is a capital felony, referencing, without saying that, the contemporaneous conviction for first-degree murder in count two. And then also goes on to say the crime of attempted first-degree murder is a felony involving the use or threat of violence to another person, referencing, without stating it, the convictions or the jury's findings appealed as to counts 3 and 4 of the indictment. So any objections to that other than those previously noted?
No, you're
right. The next aggravating factor is what's listed is that what is known as the felony murder aggravating factor, which reads the first-degree murder was committed by James Terry Colley Jr. While he was engaged in the commission of a burglary. Any objection to that?
No, Your Honor. And again, of course, with all these aggravating factors, we previously submitted motions that they, as to their constitutionality as well as applicability in this case. Do we stand on this?
Correct. So all those objections remain as standing objections. The third aggravating factor listed is the heinous, atrocious, and cruel aggravating factor. Starts off with the first degree murder was especially heinous, atrocious, or cruel. Then defines the term heinous, defines the term atrocious, and defines the term cruel. Other than previously noted objections, are there any objections from the defense?
None other than previously stated.
So noted. And if anybody identifies any typos or anything in here, let me know. The fourth aggravating factor asserted by the state with regards to the first count of the indictment is cold calculated, premeditated. First sentence reads, first degree murder. The first degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. It then goes on to define cold, calculated, and premeditated in the context of that aggravating factor. Is there any objection from the defense other than those previously noted?
Yes, actually, Judge, I do want to go into more detail on this particular aggravating factor because, Judge, we're going to ask, I am asking, that this aggravating factor not even be given as to either count in this case. There's been simply this aggravating circumstance has to require, or does require, as it's stated, a heightened level of premeditation demonstrated by a substantial period of reflection. There's been no testimony we submit from the state through any witness in this case that Mr. Colley, in committing the homicides, had or acted after a heightened level of premeditation. The jury, taking everything that the state has presented in the light most favorable to the state, as you would in a JOA proceeding, this is a case where you've had a lot of testimony that despite the injunction, the parties are around each other, had contact with one another in the days immediately preceding the homicides, that it wasn't until, and I think the state's narrowed this down to the morning of August the 27th, that during contact with Ms. Colley, that there was a reaction from Mr. Colley based upon some information about the police being involved or responding to the break-in that occurred earlier in the morning. Nothing that was presented during that time period, as well as the minutes, the hour or so after that exchange or conversation, shows a heightened level of premeditation. Even if you take the evidence that the state's presented, Mr. Colley becomes armed and goes to the house, and then, according to what was reported through the experts, sees a man, has apparently a panic attack or has a reaction to seeing the man, and then within minutes the shooting occurs and he goes inside the house, and unfortunately 2 people were shot and killed in there. Under my recollection of case law, none of that shows a heightened level of premeditation as you would in a situation like a contract murder case, or where there was some drawn-out, planned attack that led to someone's death. All the evidence shows that there was a reaction from Mr. Colley, that, again, taking what the evidence the state has presented, that he was in a state of anger, and it occurred, what happened occurred. Even in the presentation of the evidence, we don't know, although the jury has found that certainly there was premeditation here, and the court's well aware of the standard for what is considered to be premeditation under the law. When did, if you take the state's evidence in their favor, when did Mr. Colley, or when was it proven that Mr. Colley formed the intent to kill 2 people? You heard the evidence about what happened inside the house and the reactions that Mr. Colley had. None of that shows any heightened premeditation. So as I understand the case law, I've done a great deal of research on this, if there's no evidence that would support the state's theory, the state should not be entitled to present this particular aggravating circumstance either as to count 1 or count 2 of this indictment. And I would ask the court to not allow the jury to be instructed on what we call CCP.
Do you have any case law to cite that under these particular circumstances, the CCP instruction would be inappropriate?
Well, actually, I was, right now I do not. I'm going to do some research tonight, Judge, and I promise I'll have a better informed decision on that later on tonight. We had a long day yesterday, and certain things have come to mind or to raise during the course of today's proceedings. But given that we had a deposition after closing yesterday and some other things going on, I'll take a look at that. But and I've done in a prior case, I remember making the argument with regard to this in a prior death penalty case. So let me follow that up with some additional case law. But that's the argument I make as to the instructing the jury on that fact.
I'll surely entertain it after you've had a chance to do some research. But let me hear from the state with regards to the CCP instruction.
Thank you, Your Honor. I think the evidence in this particular case is plethora. What we have presented during the course of the trial, Judge, is that the defendant and his wife were going through a difficult time. They went through a divorce. Mr. Colley, the defendant, suspected that his wife was having an affair. There were many text messages, phone calls, where he clearly communicated that he was upset about this. And then we have the night before this occurred, on August the 26th of 2015, he breaks into his wife's home. He finds items within the home that he believes confirm his suspicions that his wife is having an affair. He becomes extremely angry. He breaks breaks 3 TVs in the home in a fit of anger. He takes the items from the home. He goes directly over to his neighbor, his friend. He's pointing out these items, telling him he's found the evidence. He's, again, very angry at that time. He goes to court, which had to do with his wife, a violation of injunction in that particular case. There's other phone conversations, voicemails left, where he is screaming at his wife, telling her that she's lucky that he doesn't tell the kids about what he found, and he says that she's, excuse my French, but she's fucking disgusting. Clearly demonstrating his anger, his hatred. We heard evidence that he literally had his wife logged into his phone as quote unquote bitch. He then leaves court. He has that conversation with his wife on the way there, where she tells him that after he basically told her what he had done breaking into her house, she essentially told him that the cops had been called, and as we heard testimony of the last couple of days, told him that it wasn't her that called him. It was clear references that it was Mr. Dubberly that had called the police. This made the defendant very angry. He doesn't go directly to Ms. Colley's home. He goes all the way up to Garrison Drive, which is north. If you're leaving the courthouse, it's north of Ms. Colley's residence in Mirabella. Goes to his home. There's evidence, photographs where he went to his home. He gets guns from his home. He gets ammunition from his home. We heard essentially what we refer to as a butt dial voicemail, where you hear where he's rustling through. You hear someone in the background, likely his father, saying he's an idiot. We heard a testimony from Brittany Mano that she overheard the defendant's father prior to the murder pleading with his son not to do this. And we also heard testimony from Detective Tolbert that the distance between the defendant's home on Garrison Drive to the Mirabella residence was approximately 15 miles. And then he goes to the home. He doesn't go drive into the driveway. He drives into the neighborhood behind the residence, essentially sneaks up from behind, and that's when he begins shooting into the residence. We heard the 911 calls when he enters the home. Where is he? Where is he? Where is he? We hear on the 911 calls Amanda Colley pleading for her life, put the gun down, put the gun down. We hear Ms. Colley telling him, as he's saying, where is he? No, that's Rachel and Lindy in the closet. We hear him shoot Ms. Colley. We hear him shoot into the closet. We hear him shoot Lindy Dobbins. We hear him come back. He didn't kill Amanda Colley the first time. We hear after he executed Lindy Dobbins, he comes back and shoots and essentially finishes off Amanda Colley before he then makes his flight from the jurisdiction. So that's in just a nutshell, Your Honor. When we're talking about premeditation, we talk about how there has to be an intent that's formed prior to the act of killing, and there has to be sufficient time for reflection, but that time can be very short. In this particular setting of CCP, obviously there has to be heightened premeditation. And here we see this whole situation, it begins to build in the days and in the night before. It begins to build and build and build. And there's a culmination where the defendant makes that decision that he is going, what he's going to do. He goes to his home, he gets not one gun, but he gets 2 guns, he gets ammunition, and then makes that 15-mile journey from his home to Amanda Colley's residence, where he shoots and kills her. And again, as I said, he didn't get her the first time. He shot her, shot the friend, and then came back and finished Amanda Colley off. I don't think there's any question, Judge, that in terms of this question of whether or not the jury gets to hear the instructions on CCP, that there's sufficient evidence to support that.
As it stands now, there are currently 2 versions of events out there. One is that the defendant went to the Bellagio home, walked towards the back of the home, saw what was going on inside, then went back to was angered, went back to the car, armed himself with guns, came back and proceeded to engage in the events that brought us here. The other version of events that the jury likewise could conclude took place was that the defendant left court, went to the Garrison address. We know there that he at least got ammunition. There's some, I guess, conflict as to whether both guns were in the car already or not. Maybe one, maybe both, but got some ammunition. Clearly there's evidence out there where a jury could conclude that at that point, at least at that point, he was intending to commit a murder at the Bellagio address. He then drove, as the state noted, approximately 15 miles, surreptitiously parked his vehicle on a different street at an abandoned home, and then at some point armed himself with the 2 firearms and then committed the offenses at issue. So there is at least sufficient evidence, as far as I'm concerned, that there was a substantial period of reflection to give rise to a heightened level of premeditation that a jury could find. So as it stands right now, I will give the CCP instruction. However, Mr. Wood, if you find some law to the contrary, I'm always open to hearing that, and we can address that tomorrow if you find something to the contrary.
Yes, sir. I will bring my trusted laptop home.
Okay.
All right. Speaking of that, before we move forward, though, just again on this as part 2 of my argument, I don't know if you've seen it or not, but on Sunday evening, I e-filed an objection to the definition of premeditation that's contained in the CCP instruction. It is the same argument that I made with regard to the definition of premeditation contained in the first-degree murder instructions for the guilt phase. I've inserted that verbatim into the objection, and the grounds are for the same as I did previously in the guilt phase. Since there is the definition, although it's actually just 1 paragraph in the CCP instruction as to premeditation, in the first-degree murder premeditation instruction, it's actually 2 paragraphs. But nevertheless, I felt compelled to make sure we're consistent on our argument, and we inserted the requested premeditation language for that particular aggravating circumstance.
Thank you for bringing that to my attention. I'm going to give the instruction promulgated by the Florida Supreme Court, which is the instruction that we currently have before us. So I'll deny the request for the special instruction in regards to premeditation. Moving on to the 5th aggravating circumstance asserted by the state as it pertains to count 1 of the indictment. is that the first-degree murder was committed by a person subject to a domestic violence injunction issued by a Florida judge, and the victim of the first-degree murder was the person who obtained the injunction. Other than the objections previously stated, are there any objections to that?
No additional objections.
Okay. And then with regards to count 2 of the indictment, the first 4 aggravating factors are restated. That would be the prior felony conviction or prior capital felony conviction or felony involving threat or violence, felony murder, HAC, and CCP. Other than the objections previously stated, are there any additional objections?
No, Your Honor, and also to just make sure that the record is clear on this, a request for the premeditation instruction obviously applies to both aggravating circumstances in this instruction.
Right, so noted. Then there's the instruction about victim impact, which I already gave to the jury prior to each victim impact statement being read.
Yes,
I would give that again. Is there any objections to that?
No, Your Honor.
The next paragraph, I'm now on page 4 of 11, discusses the state's burden of proof, which establishes the existence of each aggravating factor beyond a reasonable doubt, and then goes into the definition of reasonable doubt as it pertains to aggravating factors. That's that paragraph, that's 2 paragraphs, the last 2 paragraphs on page 4. Any objection other than those previously noted?
No new objection, Your Honor.
The first 2 paragraphs currently on page 5, again, state that the jury's finding as to an aggravating factor must be unanimous and must be proved beyond a reasonable doubt. Other than the previously stated objections, any objections to those first 2 paragraphs?
No, Your Honor.
All right, the next paragraph, the 3rd paragraph on page 5, also speaks to the requirement of unanimity of the aggravating factors proven beyond a reasonable doubt, and also asks the jury to make the additional finding to determine whether the aggravating factors are sufficient for a determination that the death penalty was a bracket. Better off reading it into the record than trying to paraphrase it. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. Any objection to that other than those previously stated?
No new objection.
All right, the next paragraph on page 4, continuing on to the bottom paragraph on page 5, talks about mitigating circumstances, defines mitigating circumstances, and explains to the jury that it does not need to be unanimous and does not need to be proved beyond a reasonable doubt, but only by the greater weight of the evidence. Are there any objections to those 2 paragraphs?
None other than previously stated.
All right, then beginning on page 6 of 11, going through page 7 of 11, there are 23 proposed mitigating circumstances set forth by the defense. I'll first go to the state on that. Does the state have any argument or objections to any of the 23?
Just scan through, Judge, real quick. It looks like there's been at least some evidence as to each of these, Judge.
Okay. And the 23rd is the catch-all?
Yes, sir.
All right. Anything further from the defense on that? Are there any additionals that the defense wants?
Yes, Judge, there is one. Thank you for reminding me about that. I would like to, and this has been discussed through testimony, I'd like to add, it's a little more specific than number 19, that The defendant had been previously diagnosed for depression.
Any objection to that? Any preference, Mr. Wood, as to where you want that in the sequence? Or do you have a preference?
Can we put it after 19?
All right, that'll become number 20. Read this way, Mr. Wood. James Terry Colley Jr. had previously been diagnosed with depression, period.
Yes.
You're okay with that?
Yes. No, Judge, I don't think you were asking. I don't have anything else other than that to add.
You were chatting with your client. I just want to make sure that you had anything further on that before I went further. Okay, thank you.
Judge, if we could go back to page 6, very small, grammar typo, number 13. That should be loved.
I think I pointed that out before doing this.
Oh.
When at some point, but yeah, we'll make that change.
Mine says loves, maybe I
Yours says
changed
loves.
it when you said it, but I don't know that I ever resent it.
Okay, that may be, I'm looking off the original copy.
Love the
Yeah.
Any other typos? Maybe we should read through again. I don't see any other typos. All right, going to the bottom of page 7 to the top of page 8 is the weighing process, where the jury is asked to weigh the aggravating factors against the mitigating circumstances. Other than previously stated objections, are there any objections to that?
There you go.
All right, the second paragraph on page 11 is, we'll call that the Hersey State paragraph, not the Hersey, Florida. It was the Supreme Court decision, which reads as follows: you have provided a form to reflect your findings and decision regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant would be sentenced to life in prison without the possibility of parole. Then it goes on in the next sentence to talk about balloting and how to do so.
I'm sorry.
I'm sorry.
I missed a word. Talks about what and how to do
Balloting.
so? Balloting, okay.
And how to go about doing that. Any objections other than those previously stated to those two paragraphs?
No, Your Honor, and then I guess I should just, in passing, mention that, or for the benefit of the record, mention, of course, that we did have a separate pleading a motion requesting that the instructors not instruct the jury about the requirement of unanimity for the death penalty for the arguments that we made in that prior pleading. The court had entered an order denying that pleading a motion. So, but other than previously stated, we have no additional objection.
Okay. All right, then we get into the jury's consideration of the evidence and testimony, beginning on page 11, excuse me, page 8 of 11, going to page 9 of 11. The state had included in there originally, and it seems to be appropriate, whether the witness was offered or received any money, preferred treatment, or benefit in order to get the witness to testify. There has been testimony on both sides that some of these expert witnesses have been paid. That would appear to be appropriate. Does everybody agree?
Yes, sir.
All right. And then number 7, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? There has been some of that. There have been a lot of depositions showed to witnesses, so it would seem to be appropriate that that should be given. Does everybody agree?
Yes, sir.
All right, on the bottom of page 9 is the paragraph about the defendant not testifying. I can make one change in there about his decision, right now his or her decision.
Yes, sir.
You'd be corrected as to his decision, but other than that, since the defendant did not testify, and other than any previously raised objections, are there any objections to that paragraph?
No, Your Honor.
Then beginning on page 10 of 11, There are rules for deliberation, 1 through 5. Any objections to that other than those previously stated?
There you
go. Then it tells the jury they'll be taken to the jury room, and the appropriate form will be given to them. I will go over the verdict form with them. It doesn't have a, as it does with the guilt phase instructions, a portion where it says read verdict form, but I would read the verdict form and go over the verdict form with the jury at that point. Does anybody have any objection to me doing that, or any objection to that paragraph?
There you go.
The rest of that page talks about the jury not communicating with anybody else and not taking their phones back. This is the page 10, bottom of page 10. Other than objections previously stated, are there any objections to that?
There you go.
All right. And then page 11, again, our final instructions about not contacting anybody. Looking at the evidence, the fact that the court cannot participate in deliberations, and if they have any questions, to give us a note like they did before, and that they have to follow the law. Any objections other than those previously stated?
There you go.
Okay. And I will give the instructions after your closing arguments in the penalty phase. There is no option to give it before closing arguments in the penalty phase in the standard jury instructions. Let's talk about the verdict forms. If you can get those out, there's a verdict form, separate verdict form for count 1 and count 2.
Tricia, I don't have an extra copy with me right now. This was the, you're referring to the same one that was proposed or submitted by the state?
Right.
Okay.
Do you not have it with you?
I can pull it up.
I can put it on the screen if you want.
If you can, that'd be great. Otherwise, I'll just take it a moment, pull it up on the e-form. Thank you.
All right, this tracks the most recent verdict form promulgated by the Florida Supreme Court as of March 24 of this year. Starts off with Section A, aggravating factors. It starts off by, we the jury unanimously find the state has established beyond a reasonable doubt the existence of the following aggravating factors. It then lists the 5 aggravating factors as it pertains to count 1 of the indictment. Want me to scroll down, Mr. Woods, you can see those?
Yes.
Okay. 1, 2, and 3, and then 4 and 5 are on the next page. I know you're objecting to CCP.
Yes, sir, I maintain that.
Other than that objection, any problems or objections to the language in Section A of the verdict form for count 1?
No, you don't.
In this verdict form, appropriately in bold below each section, gives the jury instructions on what to do, much like a civil verdict form. It states at the bottom of Section A, if you answer yes to at least one of the aggravating factors listed above, please proceed to Section B. If you answered no to every aggravating factor listed above, do not proceed to Section B. The defendant, James Terry Colley Jr., is not eligible for the death penalty and will be sentenced to life in prison without the possibility of parole. I presume there will be no objection to that language. Correct?
Correct.
Okay. Then we go on to Section B in the event the jury's answering Section B. The question in Section B is reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in Section A. We, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death, yes or no. Any objection to that question in Section B? All right. Then it has the instruction, if you answered yes to Section B, please proceed to Section C. If you answered no to Section B, do not proceed to Section C. The defendant, James Terry Colley Jr., will be sentenced to life in prison without the possibility of parole. Any objection to that instruction? All right. Then we go on to Section C with regards to mitigating circumstances. It's on 2 pages. I'm trying to get all of it on one for you, but it's not working for me on the screen. This is the question. One or more individual jurors find that one or more mitigating circumstance was established by a great weight of the evidence, yes or no? This is a deviation from what the instructions were prior to what the verdict form was prior to May 24th, which had the jury answer as to each mitigating circumstance. So is there any objection from the defense?
I referenced my prior request and when we were discussing this issue with regard to Justice Pariente's comment or concurring opinion in the May 24, 2018 opinion, which did modify the existing death penalty jury instructions as well as the jury form, where Justice Pariente recommended for the future that defense attorneys request of the court that the jury be polled as to each individual mitigating circumstance, so that in the event of a death penalty verdict, the court would be able to weigh the various their findings as to the various mitigating circumstances in consideration of the death penalty. We maintain our same position on that. We agree with Justice Pariente and would ask that that language, as she had even set out and proposed in that opinion, be included in this verdict form.
State want to be heard on that, or is the state just asking for the current verdict form?
I understand the defense's argument, but this is the standard verdict form, and that would be our recommendation to stick with that.
Okay. I do believe that I have the discretion to list out each mitigator and the jury to be polled on each mitigator, but I'm not going to exercise that discretion. I am going to follow the form promulgated by the Florida Supreme Court with regards to Section C and the jury's verdict as to mitigating circumstances. The instruction at the bottom of Section C tells the jury to proceed to Section D regardless of your findings in Section C. Section D is eligibility for the death penalty for count 1. Reads as follows: we, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt in Section A outweigh the mitigating circumstances established in Section C above. As to count 1, first-degree murder, and that is a yes or no. Any objection to that?
Do you?
All right. And then the instruction for Section D is, if you answered yes to Section D, please proceed to Section E. If you answer no to Section D, do not proceed. James Terry Colley will be sentenced to life in prison without the possibility of parole. Then we go to Section E, which is the final section, jury verdict as to the death penalty, which reads as follows: having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt in Section A, that the aggravating factors are sufficient to warrant a sentence of death in Section B, and that the aggravating factors outweigh the mitigating circumstances in Section D, we, the jury, unanimously find that James Terry Colley Jr. should be sentenced to death, yes or no. It then states in the instructions below that if your vote to impose death is less than unanimous, the trial court shall impose a sentence of life without the possibility of parole. The change as of May 24, prior to May 24, the form had the jury state its vote. If it was anything less than unanimous, that's no longer in there. Is there any objection by the defense to the verdict form as it currently reads?
No, you. None other than the previous stated on.
Okay, so for the record. And that's the verdict for count 1. The verdict for count 2 is identical with one difference. The only difference is that there are 4 listed aggravating circumstances rather than 5 for count 2. So any objection to the verdict form for count 2 other than those previously stated?
No, Your Honor.
If anybody spots any typographical errors, let me know. All right, I think that wraps up the jury instructions. I know I asked you all, maybe it was yesterday, I'm losing track of days at this point, how long you anticipate your closing arguments will last. The state goes first. You only get one closing argument this time, not 2. How long do you think your closing argument?
I want to say an hour and a half. I don't think it'll be that long, but I'll ask for that amount of time.
How about the defense? How long do you want? I'm not limiting you. Just once you tell me how long, I'll let you.
About that range.
About?
It's, it's hard to, no more than 2 hours, let's put it on.
Okay, I'll give each side 2 hours then.
Thank you, Judge.
All right, anything else we need to take up before we break for the day? All right, see you all at 8:45. You want to come in a little earlier and address the CCP tomorrow morning?
That'd be fine.
Let's be in at 8:30 and address the CCP issue.
Yes.
That should give us enough time to cover the case.
Thank you, Your Honor.
Thank you. Y'all have a good evening.
Dick?